kurs drži. Svaki predmet po 6. Ukupno 6. Znači, to vam je sve što ćete imati nastave.
To stvarno sam im rasporedom što smo dobili od početka, onaj red. Pa ja sam shvatila, to imamo 2 puta, da, 2 predmeta, pa 2 predmeta, pa 2 predmeta. Ono što su posljednja stala u junu, pravna klinika i public policy.
Na pravnoj klinici ćemo se mi ponovo družiti i to je malo drugačije. To treba da bude neka vrsta istraživanja, praktičnog rada, svake godine drugačije osmislimo. Prošle godine smo podelili studente u manje grupe i onda su radili ozbiljne istraživanje i pisali briefove na određene teme. Sad vidjet ćemo ove godine šta ćemo i kako ćemo. Znači, jedino ćete na pravnoj klinici ponovo biti svi, ali ćete raditi u manjim grupama. Ukoliko ne osmislimo nešto ipak drugačije u odnosu na prošlu godinu, a za sve ove ostale predmete sa izuzetkom tog krivičnog ili kriminologije. Šta je krivično ili kriminologija? Ne znam. Nije ni važno. Za sve ostale ćete imati samo tih 6 časova konsultacija.
Prvi ide 16 početak.
Anastasija, vi ste birali te neke izborne predmete ili vi tad više niste?
Ja sam izabrala samo 2. Ja sam izabrala ove predmete i kako ste.
Znači, vi završavate sad sa sledećom nedeljom, ste gotovi, nemate predmete u narednom semestru da slušate, ne?
Da, ja nekako.
Da.
Ne znam kako sve ispitno.
To morate pod hitno do kada ste vi ovde?
Do kraja februara, ja mislim.
Dobro, onda ima vremena, ali morate sledeće nedelje sa vama radi čini mi se Tanasije, koji će ispitivati ovaj predmet. I onda obavezno dođete i obavezno sa njim popričajte da, ne znam da li vam je rekao kako će da izgleda ispit, nije. Onda kad ispitajte to, pitajte ga i vidite kad biste mogli da polažete. Da obavezno polažete pre nego što otkupujete.
Da. Zato što ja sam pisala na ženi koja se pravi sad i ona je pitala me kada je želim da položim, ja sam napisala kada je
Evo dobro, onda je sve pod kontrolom. Ako je Marija u toku, Marija Vlajković ste pisali pretpostavljam, ako je ona u toku, onda ne brinite, onda će ona to dogovoriti, ali prosto Tanasije je često otutan iz zemlje i onda samo da budete sigurni da se slučajno taj vaš odlazak ne prekupi sa nekim njegovim odsustvom, odnosno da vidite pre nego što putujete da je sigurno tu, da vam da neki termin.
A za practical skills imate to?
Practical skills u stvari...
To imamo da, nama niko da odgovara. Nama je rekla profesorka Jovanović.
Milana?
Ne. Rekla da ćemo ti nekao neki mock exam, gde će ona nama to poslati, da mi uradimo, da je vratimo i odnosno to nam vratimo nije dobro, dok ne bude dobro, i na osnovu toga ćemo dobiti otet. I onda smo da prijavimo ispit u januaru, da možemo da mu upišemo. I smo da rekla što ona nam poslati posle praznika, ali nam nije poslala i onda smo se mi tu nešto zabunila, što pa već kraj januara. I onda je Martenija poslala mail, mislim da stavila
Mene nije.
Da, prošle nedelje i nama niko ništa i da odgovori. Mi da li to dobili taj exam, mi po taj mail sam nije odgovor, moramo da pogledamo da vidimo da se to desi pre roka, da možemo u roku da odemo da učimo.
Kad god imate takvu situaciju, mislim, imam iskustvo slično jer ja upravljam ovim masterom evropskih integracija i onda tu imamo isto practical skills i sličnu situaciju, onda se uvek obratite bilo Mariji, bilo profesorki Krstić, ako nema nekog duže vremena odgovora.
Morat ćemo da šaljemo. Sutra je...
Pa da, sutra iskoristite priliku da to s njom, ako se završi ovaj deo sa gostujućim predavačem. Alexandra, Saiful, Sharmarke, are you ready to start?
We're ready,
Yes,
or at least I
we are
am.
ready.
Okay, good. So as usual, I won't be seeing your hands if you raise them on the screen. Just unmute and start talking. Okay.
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 Dušanka, šta obično uradite sa svetlom? Pa bude bolje. Eto, bravo. Dobro, a? Dobro. Okay, so we have only two classes today, although an interesting but a complex topic. From the perspective that I will need some time to introduce you into basic concepts, because I suppose you are not familiar with refugee law. You do not have any previous education. You have?
Yeah. But it wasn't that much law oriented.
Mm-hmm. Okay. That's why I'll take it from the beginnings, from the basics. And if you do not understand anything, just interrupt me. So it really is terrifying that there are so many displaced people around the world. So you can see 123 million people forcibly displaced, and around half of them are women. But, you know, women, as we mentioned regarding some other topics, can be extremely vulnerable in the migration context, and in case they need international protection from another state, because their own state is not willing or able to afford them relevant protection. When I say refugee, what is the first thing that comes to your mind? Okay, but what are those running away from? War. That's what I usually hear. But as you will see, legal definition of refugee has nothing to do with war. If a person is fleeing war, armed conflict, international, civil war, nevertheless, this is not refugee from the point of international law. This may be a person, and it will be a person, in need of some kind of protection from another state. But as you will see, the definition of a refugee is very, very precise. But what is usually the case with refugees generally is that they are vulnerable. What makes them vulnerable? Can you think of something connected with refugees, the reasons why they run away, the risks that they encounter along the way to the destination country? What makes them so vulnerable?
Not knowing the language, changing the environment completely.
That's
not
right.
knowing everybody around them, not having a job.
That's right.
Yeah.
Yeah, definitely. You know, then along the way, different risks that they are facing, traffickers, smugglers, sometimes they are not even recognized by official authorities as persons who are in need of some kind of protection. Those are people who usually face uncertainty as to their destiny and final status. Those are people who usually are deprived of rights, basic rights. So you can see that different factors, here are only some of the factors that make refugees vulnerable, not all of them, but the fact that they're left home, that they are usually separated from the rest of their family. Sometimes family travel together, but sometimes, you have unaccompanied children traveling completely on their own. Just imagine how vulnerable this category of migrants can be. Now, if we just think about women refugees, so refugees in general are vulnerable. And this is something that is certified by the European Court of Human Rights. It regularly qualifies refugees as vulnerable category of persons. But then add the fact that this is a woman refugee. What are additional factors for additional vulnerability of women in refugee context? Can you think of?
They can be harassed. Yeah, be pregnant.
Yeah.
The child
Or traveling with the baby.
Excellent, Yelena, because this is something that we have to have in mind, intersectionality. Again, not every woman refugee will be equally vulnerable. If a woman is traveling with her husband or another relative, male relative, and she's wealthy and she's well educated, well, she's not as vulnerable as someone who is traveling alone or who is a single mother or caring for a child on her own. So there are different layers of vulnerability. If this is an elder woman, if this is just a young girl, all these factors are relevant. But in essence, many of these women along the way, since the entire journey is very risky, do end up in some additionally risky and harmful situations and practices that disproportionately affect women. We talked about human trafficking. Women who are migrating, refugee women also, are more exposed to becoming victims of human trafficking than some other categories of women. So those harmful practices is something that they have to deal with. They have limited access to services because once, for example, they are in a transit country or they are in the destination country, maybe they are undergoing the process of receiving refugee status in the destination country. But then where are they accommodated? In some kind of reception center, asylum center, which also may be very risky. Maybe they will face gender-based violence or sexual harassment or exploitation in the center if relevant standards are not applied. Women refugees also need specific kind of services and support, like medical services. So they also have less favorable employment opportunities than men. They cannot do construction work or in some kind of other work in gray zones. And because of that, they may become, again, vulnerable to some harmful practices. So you can see that even though the entire group, refugees as an entire group, are vulnerable, but there are some specific categories of refugees, women included, and specific categories of women that are more vulnerable than others. So what we'll be discussing this evening is, first of all, as I said, basic concepts. So who is a refugee, and how can we differentiate between a refugee and a migrant? What makes a refugee refugee? What requirements it has to satisfy? Then we will see whether the international legal framework is gender sensitive. So this is what we are going to talk about. And the thing that I owe you from the last time, the gender dimensions of the non-refoulement principle and some very recent and important case law of the European Court of Human Rights. We will do that towards the end. So, basic concepts. I suppose that you can differentiate between these categories of persons. So the widest category is foreigner. Anastasia is foreigner here in Serbia. But then you have a narrower category, migrant. Are you a migrant? No, you're not. You're just here to spend some weeks, months in Belgrade studying. Migrants, you can see they can be voluntary or forced. If a person is migrating for economic reasons, he or she chooses on her or his own whether to go to another country and find a better job and look for a better standard of living. But in some other cases, migration can be a forced one because there is no alternative to save one's life or anything else, family, well-being, than to leave the home country. So within this, again, wide category of migrants, there are those who migrate on a voluntary basis, and there are those who are forced to migrate. Then you have another even narrow category of persons. These are persons in need of international protection, which means that their own country is not able to afford them protection that they need. And then, thanks to international law and international commitments that states took, they can get protection from another state temporarily until the situation in their home country gets better. But even within this category, persons in need of international protection, you can see that you will see that there are different categories. We have refugees, we have persons who get subsidiary protection, humanitarian protection, temporary protection. I will talk about that later. But just to have in mind, their common characteristic, common feature, is that their country is not able to protect them for various reasons. And then asylum seeker, who is an asylum seeker? Someone meaning officially started the procedure in a particular country to get his or her status certified, to have a paper saying, yes, you do meet the criteria for this kind of or that kind of status, we will give you international protection.
But when they move to another country and they get international protection from another country, are they then migrants or no?
They're all migrants, but within this wide category of migrants, you have this more specific category of persons who apply for asylum. You know, for example, we have in Serbia many migrants. Some of them, you can see they came here just to work. You have those Bangladeshi nationals, Pakistani nationals, a lot of them. But then some among them may be in international protection. They left their country of origin for particular reasons, for some kind of fear, or some kind of risk that they encountered back there in their home country. And some of them, for example, while staying in Serbia, they do not want to stay here. They do not want to. They do not want Serbia to be their destination country. They just intend to pass through Serbia on their way to Western Europe. This means that they might be in need of international protection. These are people in need of international protection, but they're not asylum seekers because they did not enter the official procedure in line with Serbian legislation. Okay?
But are they then illegal migrants or?
Until they apply for asylum, they are. Once they apply for asylum, they cannot be punished for illegal entry. Okay? If we are talking about persons who enter the country illegally, which is usually the case with persons who are in need of international protection.
You can enter the country illegally, but you need to apply for asylum to make it.
You shouldn't. I mean, there are official border control points where you should, come and then try to enter the country. But in case you do not have documents, in case you do not have visa and your nationality needs visa to enter into Serbia or any other country, then what will you do? You will, go through forests, mount through mountains where there are no official border crossings and try to enter in that way. If you are spotted by police somewhere along the way on the territory of Serbia, what will happen? You will be detained because you are illegally present on the territory of Serbia. But if you, in this first encounter with the authorities or at any later point, say, I ask asylum, this means that you cannot be punished for illegal entry because you might be in need of international protection. Whether you are or not, this is something to be determined along this asylum procedure. Okay? Is this clear?
Yeah, but if they enter regularly,
Okay.
but they don't have their, say, they don't have the residency stated in the whatever it should be stated. Are they then considered illegal or illegal after?
If they're,
48 hours?
I did not understand you. So they enter legally. They have passport, they have visa, okay. So what's the problem? But still, they can enter into asylum procedure if they want to get refugee status or any kind of other international protection in Serbia.
But they need to say where they're staying.
Yes, they will have to give the address. If they do not have the address, there are asylum centers where they can be accommodated. So there is the whole system.
You're in danger.
We'll come to that. This is very, very difficult. This is very difficult to prove, especially if you don't have documents. If you cannot prove who you are, where you come from, it's just your word, But I mean, persons who work for the asylum office or immigration authorities, they are trained to assess the situation and to ask relevant questions, But I will come to that later. Okay, so now the most vulnerable category, those who may be qualified as refugees. This is defined by the United Nations Convention on the Status of Refugees, a very old document which was adopted and concluded after World War II to solve the problem of World War II refugees. However, it became obvious that there were more and more situations in the world, armed conflicts, etc., that made people flee, and this problem was never resolved. So this convention is still in force today, and here you have the elements. So what does it mean? What a person has to meet as conditions in order to be considered as a refugee from the legal point of view? First of all, that the person is outside the country of origin. This is quite clear. So he left his country of origin. The second one, that the person has a well-founded fear. What does it mean, well-founded fear? Both subjective and objective elements need to be there. So I need to fear from something which is objectively a reason to fear, not just something in my head. Yeah, but also there needs to be a subjective element present. Fear from what? Fear from persecution. So this is the term used by the convention, persecution. How do you understand that? that a person may be persecuted back home.
So if they have also in a form of tension,
Definitely.
see that, but also if they are part of the LGBT community and being gay, it's punished by that.
Yeah, definitely. So basically, serious violation of basic human rights. The fact that, for example, there are problematic laws in the country of origin that target a particular group of persons, or that, the system, the institutions are not functioning. And for example, if the example that you gave, this person, even if he or she turns to the court, to the police, it will not get any protection and will not solve his.
Where right now in Croatia, they cannot come back here because they are in Europe.
That's right. That's a cool example of what we are talking about. But the persecution needs to be linked to one of 5 conventional grounds. So the persecution has to be for specific reasons, either someone's race, religion, nationality, political opinion, or membership in a social group. And that's it. Not a lot. That's why I told you, we always associate refugees with war. But do you recognize war here? Might be. And if it is there, the person will be a refugee. But simply, I fear for my life. There are bombs. People are fighting, firearms using. I will go to another state. No, this is not the situation that meets these conditions. Ellen, I wanted to.
I think that's what is membership in social group.
Excellent. So we can interpret it extensively. Something that Dushenka mentioned earlier, LGBTI persons who do face serious deprivation of basic human rights all over the world, they can be considered a social group. Women, what we are going to talk today, women.
So we can also from that side.
This final ground is very useful to make the convention even adaptable to the present day conditions. The other ones are pretty clear, but the last one was deliberately left with this wording to enable other categories to fit the definition. Okay, so do you now know the criteria? Because I'm going to case studies now just to check whether you understood correctly. So you see, who is a refugee? Only a person who meets those very precise elements. And this is the first option within this wider concept of people in need of international protection. So even among people who need some kind of international protection, you can see that there are different people. Some of them will be refugees because they do meet these different criteria. Others who, for example, flee war or who will face torture upon return to their country of origin. We talked about torture last time. Or they face capital punishment back home. They will not be refugees if they do not meet those specific criteria, persecution on one of 5 conventional grounds. Still, they can get subsidiary protection. This is another kind of international protection, which is basically substantively the same as refugee status. So in terms of rights and duties, there are no differences, but simply the idea is, yes, there are people who are running away from war. They need to be protected from not fit the refugee convention. Let's give them another kind of status. And this is subsidiary protection. Okay, this is not something regulated by the refugee convention. As I mentioned, this is a very old document, but subsidiary protection is something which is there in EU law, which is there in our law on asylum and temporary protection. So this is a very established, well-established concept, okay? Then you have protection on humanitarian grounds. We talked about victims of human trafficking. If you have a person who is a victim of human trafficking, and if she goes back to her country, she will again end up in the trafficking chain, and police is not doing anything. The authorities are not able to give her protection. Then she can get humanitarian protection. So, or for health reasons, sometimes, but this is discretionary. This is upon the state to decide whether it will give protection to someone who is ill, who needs protection on other grounds.
For that specific case in trafficking, that's a victim receive this protection in their own country or any other one that she did.
I don't understand.
So you said when the person comes back home, again, police doesn't do anything, and she ends up again in the traffic chain, so she can seek the protection.
If she would, if she was to be returned, she's currently, for example, she's currently here. She was detected by our police officers, and she's a foreign national.
But she needs to be a foreign national too.
Of course. I mean, this is all about foreign nationals. I mean, you cannot afford international protection to your own nationals. It makes no sense. Yeah. So we are talking about foreigners. And last but not least, there is temporary protection. For example, Ukrainian refugees. Once the war in Ukraine started, they, in large numbers, started entering EU countries. And the European Union, for the first time, activated this directive on temporary protection. What's the purpose? When there are so many people asking for protection, and you do not have enough time to, go into specific procedures and to look into the facts of each particular case, and they all meet some kind of general criteria. I mean, they all come from the same country. They all face same risks, then you can afford them temporary protection without checking once the war is over, of course. But this is temporary protection, just for those mass influxes of persons in need of international protection. Okay.
So in my previous work, I was working with some journalists from Georgia. And in Georgia, they have a foreign agent law, which is like a law forbidding for the NGOs.
Yeah, I know.
So they are like the country, and they're not in the EU. But I'm not sure how it is possible for them to get international protection.
But they do need to, because
But they were breaking the law in their.
But never mind. Sometimes even law can be a cause for persecution. The law is problematic. Just imagine having a law. We'll talk about that later. Having a law regulating female genital mutilation. Does it mean that the person who fled from that country in order to not be exposed to FGM, that practice is just legal because this is something regulated by law? No. So you need to objectively assess the situation. And of course, the person who would be assessing the asylum application, that's what you asked earlier, what that person needs to do. It needs to check country of origin information, but objective, neutral country of origin information, not information provided by the very country from which the person fled, but information given by UNHCR, by Amnesty International, by other respectable NGOs, or local NGOs who also report certain practices that are problematic, and for which, for example, a person working for an NGO which is, trying to find a corrupted government or anything else, that they will face persecution because of their work and, in a way, political opinion. So you
It
can.
doesn't matter if it's breaking the law in that.
No. What is relevant is, general standards that should be applicable. The country of origin can, make sexual exploitation legal, but this does not mean that the person will not meet the conditions for being protected by another country. Case study 1. Mara is a journalist. She is very critical of the increasingly repressive government of country A, which is corrupt and suppresses freedom of expression. After writing an article about the government's corrupt projects, her editor asked her to write another article about illegal detention centers. That evening, she received threats that she would be killed if she wrote another article against the government. The next morning, she took a bus to the capital of country A, where she has friends. Is Mara a refugee?
Because it's the same person.
Excellent. Very well. That's what I wanted from you. So those who are online, maybe you did not hear Jelena. She said she is still in her own country, so she did not leave the country, and that is the first condition for meeting the refugee definition. Let's go to the second case study. Anna and her partner Maya came from country A to country B. In country A, they could not lead a normal life because they were lesbians. There, she started working as a professor at the law faculty, but when her relationship was discovered, the dean fired her on the grounds that her private life was jeopardizing the reputation of the faculty. He did not want to write her a letter of recommendation, which was necessary to find another job at the academia. Are Anna and Maya refugees?
Oh, because they were not fearing for their life.
Well, lead a normal life, and we dive into it, maybe. But I think because they had work here.
What might be missing here? Which condition? You remember the persecution. Persecution, yeah. Of course, these are very scarce facts. We only know that she got fired and that the dean did not want to issue a letter of recommendation, which she obviously needs. But if there is a systematic practice in that country of treating lesbian persons in that particular way, they cannot, if they turn to relevant institutions to get satisfaction, to protect their own rights. If they cannot get those rights, then this would be a different situation. So it really depends. What I want you to have in mind, it depends on all the facts of the case, on all the circumstances of the case. Everything counts, both situation in the country of origin and specific personal situations of the asylum applicants. Everything counts. So just one fact, one circumstance might completely change the picture, and you would say that they meet the refugee definition. But when it comes to grounds, this is fulfilled because if you remember, this membership in a particular social group, LGBTI persons, this is now general standard. This fits the ground. Case study 3. Myra and her 3 children come from country A. A civil war has broken out there. To save their lives, she and her family left country A and are now in country B. Are they refugees? But what did I say?
Yeah,
War does not mean that you're a refugee. What is there? Another kind of protection. You remember? Subsidiary protection. Excellent, Dushinka.
He's
So,
refugee here. Case study 3
Sorry?
is must be refugee.
I suppose it's you, Simon, but I could not hear you.
I told case in case of case study 3, 3 that is they must be
In case study
refugee.
3.
Yeah, they must be refugee. Must be refugee.
They are not refugees, they are candidates for subsidiary protection, okay? Because subsidiary protection is given to persons who run away from war. So these they will not be refugees because they do not fit the criteria. They did leave the country. That's the criteria that they do meet, but they are not facing persecution on a particular ground. Anastasia, do you follow me? Yes or no? I think no. So you remember, Anastasia, very precise definition of a refugee according to international law. You here in these elements, there is no war. If a person is just running away from war, this does not mean that he or she meets the criteria. He or she might. But if they have well-founded fear of persecution on one of 5 conventional grounds.
But what if they are running from the war because of their political opinion?
Then that would change the situation. For example, if this is a civil war against two groups, you have pro-government groups and you have rebellions, and
it can be
of the race, of course,
the war,
of course. That's what happens. That's what I want you to understand. War might be there, but a person needs to meet these additional criteria to be a refugee. If there are no these additional criteria, just running from war, then those persons qualify for subsidiary protection.
We said about a specific social group. Myra is a woman. We said that women are.
But we do not have here the information that she is running away because women are treated this or that way in her home country.
That's the question. So this is if they would seek refugee protection or subsidiary protection. But is this protection connected with asylum?
Asylum is a general term.
Yeah, but if they can seek asylum.
Yes.
Even if they
they will seek asylum. Asylum equals international protection. So these are synonyms, okay? And once they seek asylum, the asylum officer will check the facts of the case, circumstances, and say, you are a refugee, or no, you are not a refugee, but you are a candidate for subsidiary protection. So they do not, on their own, have to know about who is the refugee, who is a subsidiary, who is a candidate for subsidiary protection.
If they are one or other, affect the possibility of getting it. Are equal, can equally.
For example, how can let's say I'm illiterate, I'm not educated, so I don't know these things, and I go to another country, and I don't know that I need to tell to the officer that I'm a woman who is threatened because
they will ask you. They should ask. They should ask you different questions. You say, you do not have to say, I want asylum. You do not even have to know about that word. But if you say, I'm running away from this or that happened to me, that should be enough for the border police or any other official that you are in contact with to, tell you about your rights. You might qualify for asylum protection, international protection, whether refugee, whether subsidiary protection, never mind. This will be determined along the procedure. So this is not up to you to think about those things. The asylum officer should ask you relevant questions and based on what you tell them, qualify you for what kind of protection you should get. They can refuse your application and eventually send you back, unless, you know, the non-refoulement principle, which we'll talk about later, applies. That they, even if you do not meet the criteria, you are not a refugee, but there are some serious reasons for which they should not return you back to your country. Mm-hmm. This might also happen, you know. Have in mind, for example, a terrorist who came here. He does not deserve international protection. Mm-hmm. But if he will be tortured once returned, there is a risk that he might face torture if returned to his country of origin, because the authorities are looking for him there. You should not send him back, because torture is an absolute prohibition, and under no conditions can you return such a person there. Mm-hmm. But for any other person, this also applies. Even if he does or she do not meet these very strict criteria, if the asylum authorities should have in mind the non-refoulement principle and not send a person back if the person would dare face, for example, the risk of torture. But I will come to that later, okay? Case study 4. Tara lived in a poor region in country A. Since losing her father, she had been supporting her mother and 3 young brothers. An acquaintance offered her a 3-month job in country B as a nanny and cook for a wealthy family. When she arrived in the capital of country B, a friend of her acquaintance picked her up, took her passport, and forced her to work in a nightclub to pay for the trip. Is Tara a refugee? But what makes her a refugee?
She's in another country.
Okay.
She is probably having a fear because she's
Really nice.
look to the reason why she left her country, why she left.
Anastasia, excellent. Why did she leave her country?
Because of job.
She wanted better life. Unfortunately, she ended up as a victim of human trafficking. But this does not make her a refugee. This does not mean that if returned back to her country of origin, she would face persecution. Persecution from the state or from non-state actors, private persons, but the state is not able to give you protection from those non-state actors and private persons. Okay, so she's not a refugee. She does not need subsidiary protection, might qualify for humanitarian protection because she's a victim of human trafficking, but this is something else. There is no persecution here. She's just a victim of human trafficking. And final one. Marta comes from country X. In country X, she was a victim of domestic violence. She tried to get protection from the police, but the police officers told her to go home because what happens in someone's home is none of their business. When she filed a criminal complaint against her husband, it was dismissed on grounds that the threats she was receiving were not substantiated. Now we are linking refugee law and gender, because this case scenario is very specific. So what do you think? Does Marta qualify for the refugee status? Think better. or try to think.
Persecution.
Persecution.
Yeah, but states also could not.
Excellent, Elena. And that is relevant. So the persecution does not have to come from private person, her husband. She tried to ask for protection in her country of origin. But obviously, this is a systematic problem back there. It's not just one police officer who doesn't want to do his job properly. So obviously, what police has as an attitude is, no, what your husband and you do within your home, this is your private matter. It does not concern us. Remember the criteria for the refugee status. First, outside the country of origin. Is she outside the country of origin? Yes. one, the well-founded fear, which needs to be there objectively and subjectively. How would you argument that this fear, in her case, is there objectively? She already experienced that, and so the fear is very objective. What else? She did not get relevant protection once she asked for that protection. So there is both this objective and subjective. She's obviously subjectively afraid of what might happen to her, but objectively as well. Well-founded fear of what? Of persecution. As I mentioned, persecution is a very extensive concept. Persecution means different things, but not getting protection from the authorities once you ask for it and not being able to get it is also persecution, because there are obviously not functional institutional administrative procedures for protecting the person from domestic violence. And the last criteria of one of the 5 conventional grounds, the situation is here obvious. You remember race, religion, political opinion, nothing of that, but membership in a particular social group. So women may be considered a particular social group. And this is now part of the jurisprudence of different international bodies, national bodies, even our asylum authorities interpret social group in that way. Okay, now let's go to the international legal framework. What we have here as the most important document is this very old convention that mentioned the 51 Convention of States of Refugees. This is the Bible of refugee law. On the level of European Union, we have common European asylum system. Have you heard about it? So these are different regulations that directives to EU member states try to harmonize their national legislations in the area of asylum. Then, what should not be neglected is international human rights law. It's always useful, and it's always, basic. Here we have, for example, the International Covenant of Human Rights, the universal instrument. We also have the European Convention of Human Rights as the regional one. Neither one of them guarantees right to asylum as a specific right. So if you read the European Convention of Human Rights or the Covenant on Asylum and Political Rights, you will not find legal provisions saying everyone has the right to seek asylum. There's no such provision. But that doesn't mean that asylum seekers, persons who need international protection, are not protected by the European Convention or the Covenant. No, they are. Because they are entitled to all the other rights that are there. They cannot go before the European Court of Human Rights or the Human Rights Committee and say, in the Republic of Serbia, they violated my right to asylum. They cannot do that because there is no right to asylum guaranteed by these instruments. But they can go before the European Court of Human Rights and claim, I was a victim of torture. My right to private life was violated because I was separated from my family. The authorities did not allow my minor child to connect with me, to come to this country so that we can live a family life together. CEDAW, why is it relevant? Or gender aspects of refugee law, it is very relevant because, we mentioned that a number of times. CEDAW establishes standards through general recommendations, general comments. And there is, for example, one which concerns women in refugee situations. So very useful one. And last but not least, Istanbul Convention. The Istanbul Convention, the one which is regional within the Council of Europe, and the aim is to protect women from domestic violence and gender-based violence. There is specific chapter in this convention dealing with refugee migrant women, stating that asylum procedures should be gender sensitive, that gender-based violence can be a form of persecution and persecution for the fulfillment of those criteria of refugee status, and prohibiting criminal return of women if they would face gender-based violence and domestic violence in their country of origin. So the Istanbul Convention is very useful in this regard. Just curious, just a very interesting fact. In this old 51 Convention on the Status of Refugees, as I mentioned, there is nothing about gender or gender equality or protection of women, which is, logical if you take into account the year when this was concluded. But the US delegation, our delegation, proposed during the negotiations to conclude this treaty to include the term sex or other reasons as ground for prosecution, and this was rejected. This would be very helpful. Still, we have this membership of a political social group, which serves the purpose. So, ways to overcome this lack of sensitive visions is to simply acknowledge that women or particular groups of women do fit within this particular social group ground or getting refugee protection. Current European asylum system. You have here on the slide, I won't go into details, but as I said, the common European asylum system, these directives of the EU law, they are very, very detailed and precise in this term, in these terms regarding gender sensitive provisions. You can, on your own, go through this qualification directive, asylum procedures directive, reception conditions directive. They all really thoroughly and in a good, appropriate manner take gender into account when providing for relevant commitments for states. Even the Court of Justice of the EU did have before it several cases in which member states asked the court for clarification of the state's determination when it comes to women as a particular social group. You have here, I selected this case C621 from 21, where the French Chamber held that women in general and women facing domestic violence in their country of origin in particular qualify as a social group for the purpose of determining refugee status. So now, after this case, you have it black and white that women do fit this ground membership of a particular social group. There was another interesting case of two Afghan girls who asked for asylum in an EU member state. I don't remember which one, never mind. And they said that they should qualify for refugee status because they are women, Afghan women, who accepted Western values. And because of that, if they should be returned to Afghanistan, they would face persecution. Just because of being women who identify with Western values. Do you think the court accepted that? Yes, it did. It did. So you can see that this it can also be a political opinion. Yes. Yeah. Yes. Yeah. But obviously, we do not have to go there. Simply the fact that there are women who do not fit anymore into this society that they left is enough for considering them members of a particular social group and ones who meet the criteria for refugee status. CEDAW, I mentioned there is no specific provision of protection of migrant and refugee women, but as usual, we get very relevant guidance and standards from the CEDAW committee. There is the general recommendation number 32 on the gender-related dimensions of refugee status, asylum, nationality, and status of women. What the committee generally says is CEDAW and the Refugee Convention complement each other. There are no gender-sensitive provisions in the Refugee Convention. There are no specific in the CEDAW Convention, but they should be read together because they complement each other. And for those reasons, the Convention serves to prohibit sex and gender-based discrimination at every stage of the displacement cycle. During the refugee status determination procedure, throughout the return or resettlement process, and throughout the integration process for women who have been part of asylum. So along the way, from the moment they leave the country until the moment they are integrated into the new society, gender aspects need to be taken into account. Yeah.
When they get asylum, what does that mean? They don't have a permission to legally be in this country, or they also get some for finding a job, a house.
They have very specific rights to work, rights to be educated. Children, they can go to school. All different rights that they might need in order to integrate it. The language, for example, they have to say. Well, this is something the state should be then doing, trying to make the best possible efforts to integrate them into their own society. They give them asylum, give them refugee or subsidiary protection. Then you should think about how they will fit the society. There are courses, for example, for learning Serbian language that are offered to them. If they cannot find, they should manage, by finding jobs to do, provide for themselves. But if they're not able to, there are always asylum centers where they can temporarily be accommodated. But it's just temporary. So the point is to make them independent, to make them be able to care for their own. On their own.
That would
asylum claims and in order to promote in gender context. Now we're going towards the end. If you now know the elements of the refugee status, let's go into specific details when it comes to gender. So remember that one of the conditions is persecution. How does this term relate to gender? Well, because some forms of persecution are directed against women because they're women. Or there are some forms of persecution that disproportionately affect women. Women are more often victims of those acts, persecutory acts, than men. What in particular? Women might face persecution as punishment for disobeying certain social and cultural norms. There is forced marriage. Woman opposes it, does not want to get into forced marriage. It's a persecution. When a law policy or practice severely restricts the right to women, such as the practice of genital mutilation. In Nigeria,
be abortion.
it can be.
So if have a law which is prohibiting abortion.
It can be.
You can.
Yes. Sometimes this does not have to be regulated by law, but you may have some practices or methods of implementing relevant law or legislation that might be statutory in nature and might qualify as persecution for forced abortion or forced sterilization, or last but not least, with regard to the legal framework, everything is fine. But then, at the level of implementation, you do not get protection, domestic violence, usually. So this is also persecution if you do not, if you cannot get relevant protection. So what in particular? Aggravated or cumulative forms of discrimination against women amount to persecution in the country of origin. Trafficking in women. This can also be persecution. Because, this past experience of being a victim of human trafficking might be considered persecution. If, again, back in the country of origin, that victim of human trafficking would not get and could not get relevant protection. Because, for example, the traffickers and the police work together. Female genital mutilation, obviously. Forced early marriage, threat of violence, and also called honor crimes. Rape and other forms of sexual assault in certain circumstances. Serious forms of domestic violence, forced sterilization. Imposition of the death penalty or other physical punishments existing in discriminatory justice systems. Systems where women are stoned to death just for adultery. So this is gender-based persecution. Or political or religious persecution for holding feminist abuse. This is then you have two grounds. You have ground because of women who express feminist opinion, but also this is kind of political opinion, something that you mentioned earlier. So you can see that there is a wide range of different acts, practices that are gender-based, that may count as persecution for the purpose of meeting the requirements of the regulation. When it comes to the ground, we said women in general in a particular country may be considered particular social if they in general face systematic discrimination. But then certain categories of women can also count. Which categories? Some of them we mentioned it. Being victim of domestic violence. But if they face persecution, there are systematic problems. So just have in mind also women who are victims of FGM. Different categories of women may also fulfill this criteria and do not have to have this situation of persecution of women in general in the country. A specific group of women may also count for the purpose of meeting the refugee definition. Married women who are able to leave their relationship. If you have such traditional practices in the country of origin where women cannot separate divorce from husband, then they can also be considered as a particular group of women. During the asylum procedures, once they apply for asylum, what should be taken care of? Is it okay to just do the interview? Yes, the asylum authorities just do the interview with the head of the family. 5 minutes. No, obviously not. Why not? Because, if you have this subordinate position of the woman, she will not allow to speak in English, she will be silent, and the asylum officer will not be able to get any information from them. Very important information because maybe domestic violence is going on. While women are interviewed, they should be interviewed by same-sex interviewers. The same applies for interpreters because here we are talking about foreign women. They will need usually interpreters because migrants, persons in need of international protection in Serbia, they come from countries that they do not speak English or French. They usually speak only their native language. We do not have many translators here. Sometimes it's even difficult to provide them the translator of the same sex. So this is not imperative, but should be fulfilled in case it's possible. To interview women asylum seekers without the presence of their husbands and male family members. To be attentive to indicators that indicate the need for special procedural guarantees for vulnerable categories of women. What does this mean?
To not only the interview.
Domestic violence. So this needs to be checked.
What is the name of this in Serbia?
We have the asylum office as the first instance.
Where is it?
On the border. It's in Belgrade, but they travel to the asylum centers, which are all over Serbia, and do the interviews there. So the asylum office is a department within the Ministry of Interior, which is not the best possible solution. Imagine why you have people who are fleeing their countries of origin. Usually they could not get protection from their own country and had difficult experience with the police usually. And then you have a police officer interviewing. Of course, they're not uniforms, they're dressed like civilians, asylum officers, but still, the entire system in the Ministry of Interior is pretty hierarchical. You have some discussion, but it is always your subordinate. If he or she tells you, no, you cannot give this person asylum protection, you have to obey, you have to listen. So this is a bit problematic. At least in Serbia, in some other countries, this is not like that. But the asylum office is the one who is interviewing and assessing the asylum application in the first instance. If the asylum officer or immigration officer in another country, according to these indicators, might think that this person is a victim of human trafficking or gender-based violence, what should he do? He cannot deal with this on his or her own. So multi-sectoral cooperation is essential for it. Because then there are other institutions that should include someone who is trained to work with victims of human trafficking or domestic violence or gender-based violence. So to just show this person the way further to other services and institutions that may be support to that person. Okay. So asylum office, then asylum commission, and then the ministry report. These are the three instances, at least in Serbia. And of course, to apply special procedural guarantees to vulnerable categories of women. This is something that we thought. If you have a woman who is victim of torture or FGM or human trafficking, then there NGOs who deal with human trafficking victims. There is the Center for Human Trafficking Victims, which is a state body. So then you should connect with them and simultaneously include various state bodies to provide relevant support to that person. And the last topic, the non-recruitment principle. Finally, we come to that. So what does it mean? This is the most important principle of international refugee law. But it may mean various things depending on the legal framework. You remember last time we talked about prohibition of torture, inhuman degrading treatment. Every treaty has a specific definition of what is torture, what is inhuman degrading treatment. Similar here. So depending on the legal framework, this might mean different things. But generally, this means that the country cannot return the person to his or her country of origin or to any other third country in case that person would face there some serious violations of his or her basic rights. Where do we find the legal basis of the non-refoulement principle? There are some treaties that guarantee it explicitly. You have the UN Convention on the Status of Refugees, the ones that we were talking about, famous Article 33, the non-refoulement principle. If this principle is contained in the Convention on the Status of Refugees, who does this principle protect? Only refugees. So only persons who meet the criteria for refugees. However, there is the UN Convention against torture. We talked about it last time. Article 3 prohibits return of persons in case they would face the risk of torture upon return. Who does this provision protect? Anyone. You can see the difference. So depending on the legal framework, this principle may mean different things or may protect different categories of persons. But generally, the idea is to protect the person from not being returned where it would face usual torture. In some treaties, it is contained implicitly. Take a look here. The 1950 European Convention on Human Rights Environment. So the European Convention of Human Rights. You will not find an explicit provision prohibiting return, refoulement. But what is logical?
There is a great danger in someone's life.
And torture. Excellent vision. Excellent. So those two provisions, Article 2, right to life, Article 3, prohibition of torture, they are interpreted, they have been interpreted by the European Court of Human Rights as implicitly including the non-refoulement principle, because it's the same, you know, if you are torturing the person on your territory, or if you do not torture a person on your territory, but you simply return him or her to a country where he would be exposed to torture, any difference? No, the effect is the same. The person is exposed to torture. So this is very important to know about the European Convention, and the same applies to the problem of the similarity.
With the hearing situation, because the European Convention is the regional instrument. But what if the person who is seeking the capital convention is from Asia?
The relevant thing is in which on the territory, in the jurisdiction of which country that person is. So you have, I don't know, an Iraqi national in Serbia. We are part of the European Convention of Human Rights. Regardless of the fact that he's an Iraqi national, we cannot return him, and we have to guarantee him all the rights provided in the European Convention. It's not just any principle, this is also a normal customary law. What does it mean? Even for such states as the USA that are not fans of human rights treaties, this is an obligation.
have a question. So, if we have, for example, water credit, and the country of origin wants to and he goes to the country and they seek asylum and said that they are given exposure because he's arrested. Can then he
No, because there are exceptions to refugee status. We don't have enough time, so I could not cover everything. I tried to cover the basics, but this is regulated by the Refugee Convention. Persons who are who have committed crimes contrary to the principles of the United Nations, and war crimes are definitely contrary to the principles of the UN. They do not deserve refugee protection. But this does not mean that you can return. Remember, this prohibition of refoulement is absolute. You will not give that person protection, if not the refugee. You cannot return him. What you will do with him, you can decide. You can keep him in your prison. You can ask another country to take him to their prison if they have interest in doing that. You have to find some kind of solution for that person, but you cannot. But the solution is prison. Right. Not necessarily in prison, just giving you the most radical example. You have a very dangerous person. Sometimes
we had some cases that some nations like Russia and Europe, because they would get arrested. That's the case.
yeah, this happens. It doesn't mean that the country will always act in line with its international commitments. I'm teaching you law, but I'm not saying that it's always working and that's always being fast. What's going on? Okay, so I will skip these. These are the provisions in the UN Refugee Convention on the prohibition of non-refoulement, Article 3 of the Convention against torture. But let's focus on the Article 3 of the European Convention on Human Rights. We discussed it last time, you remember. No one should be subjected to torture or to inhuman, degrading treatment or punishment. Is there a non-refoulement constitution here? No, it's not explicitly. But if you remember, I told you it is there implicitly, thanks to the case law of the European Court of Human Rights. It started with this Zering versus UK case. This young man was national of Germany, and he went to the USA, and there he killed parents of his girlfriend. The USA, he then managed to escape back to Europe. He was in the UK, and USA tried him in absentia, and they sentenced him to death. And they asked UK to return him, extradite him, deport him, whatever, back to the USA. And then UK thought, should we do that? Are we allowed to do that? The case ended up before the European Court of Human Rights. And then the court said, no, this would amount to torture. Because back in the USA, he would face the so-called whole of death, whole extremity. The fact that he would be waiting so long for the execution of the capital punishment would be torture. And you are not allowed to, or returning him would be a violation of Article 3. It all starts with this case. You can see that this person was not a refugee, he was not a migrant, just a regular person. But then this concept of the implicit prohibition of refoulement within the prohibition of torture started to be applied by the court in other areas as well, including asylum and refugee law. So soon we had quite a number of cases where applicants were actually asylum seekers or refugees who applied to the court saying, if we are returned back to our country of origin, there we would face torture. This country should not do that. Otherwise, it will be a violation of their European Convention treaties. And the courts accepted that. Okay. So today, this is a well-established practice of European work rights, meaning that before returning the person to the country of origin or to any other country from which he came, what do you need to do? What the authorities need to do? Check what? Check the risks that he or she will be facing in return. So this probability, what is the scenario that will happen to a person if that person wants to be returned? What should be assessed? You have here two elements. The first one, material conditions in the country of return. It's also personal circumstances. So generally the situation in the country of return, but also personal circumstances, individual circumstances of the applicant. Everything matters. These two groups of circumstances should then give you foreseeable consequences of the return decision. What are the risks? What will most probably happen if a person is returned? What are material conditions in the country of origin? General situation regarding human rights, if there are gross human rights abuses, violations, if there is political unrest, if there are armed conflict. How is it assessed? I would mention the country of origin information published by relevant international organizations, NGOs. This is valuable. However, for example, asylum officers, that they have a specific section in the asylum office who deals only with country of origin information. You have an asylum seeker coming from Afghanistan, you go to the officer that does country of origin information and they the latest information on the situation in Afghanistan. Generally, and with regard to this particular group. How do gender aspects fit here? And are they relevant in the context of this material conditions in the country? Yes, of course. In what way in particular? And for example, general situation of women, maybe rights, but they're protected, what the legislation, what are the practices, so everything counts. Gender aspect is quite relevant for this material aspect. So, for example, widespread gender-based violence would be very significant information regarding this first aspect. When it comes to individual circumstances, gender may also count. So, what are individual circumstances? Maybe not all women in the country of origin face discrimination or some kind of persecution. But maybe this particular person, this woman, was a victim of gender-based of domestic violence or gender-based violence or human trafficking. And for this or that reason, she could not get protection from the authorities. So her personal circumstances would that matter. So what I want you to have in mind that in both elements, material conditions, personal circumstances, gender counts, gender might count. I focused on the Article 3 of the European Convention of Rights. And I told you that it implicitly contains also the contribution to return a person to the country of origin. But the court has very, very high threshold in general, not only regarding gender-based violence cases and cases that concern us here. In general, it has very, very high threshold, meaning that the source of risk would have to, the situations would have to be very exceptional circumstances. So this is the standard that the court wants. Or compelling humanitarian considerations. What is the idea? The idea of the court is that the European Convention is not there to protect everyone from anything. It is there to protect persons who are in very exceptional circumstances and would risk being tortured once returned. But this is the standard. Very exceptional circumstances, okay? I want you to remember this because for the end, we are going to solve certain case studies. Here, and they're great. So first, the applicant and her two daughters claimed the girls risked female genital mutilation if the family was returned to Nigeria. They alleged that the mother's eldest daughter died, aged 1, from profuse bleeding after female genital mutilation was performed by an elder. The family left Nigeria for Ireland in the face of pressure from the father's family to perform female genital mutilation on the two young girls. And now they're facing return to Nigeria. What do you think? Would this be a violation of Article 3 and of the implicitly involved principle of non-prohibition of non-prohibition if this family, these two young girls, were to be sent back to Nigeria? Okay, why?
Because the fall of this procedure happened when they, as well as also punishment for fleeing the country. In addition to the fact that one of the people three are considered for torture.
Let me tell you what's the standard. Very exceptional circumstances. I would agree with you. I was giving them protection as well. But have in mind, the European Court of Human Rights is very, very high threshold for very exceptional circumstances. What if I tell you, we do not have here the entire complete facts of the case, but what if I tell you that the parents are well situated, they are wealthy, they own a house, they have cars, the father and mother of the other parent is against FGM, and they are very influential in Nigeria. In Nigeria, there are parts of Nigeria in which FGM is prohibited. So they also have the option to relocate to another part of Nigeria and live secure life there. Does this change your opinion?
Yes. Yeah, it changed. But to be honest, because they are local and they have this kind of consider many other people in Nigeria. So I think people can understand that it's not a great thing in terms of because they have all this facility. But for many other people, it is. So I think it would make a groundbreaking.
Well, here's what the court said. Not in dispute, FGM would amount to it. The court does not dispute that. They say FGM is torture. But the crucial issue, whether the applicants would face the real risk of being subjected to FGM upon return to Nigeria. That is the crucial thing. And then the court used these arguments that I gave you, together with the fact that they could not prove what they were saying about their eldest daughter, that she died because of that. They could not prove that. They did not have that certificate. They did not have any. So that was just their allegations. So you can see. And what also the court noticed, no, there was no attempt of either by mother or father to report any issue concerning their daughters and that she had to police to seek help. So they did not go to the authorities. That can be a first try to get protection from the authorities. If they are not willing or able to find the protection, then the situation would be different. Take a look at this case. The applicant born 1973 fled Nigeria in 2003 to avoid female genital mutilation. Her sister had already died of the consequences, and she alleged there was a risk villagers would kill her if she refused. Her mother had told her she must cooperate. There are differences in this case as opposed to the first one. You can feel the difference. But do you think that the court found a violation of Article 3 in this case? No. Why not? Again, it said, not in dispute. FGM is ill treatment, is torture. But the court said there is internal flight alternative. We can't have Nigeria. So there are certain parts of Nigeria in which FGM is not practiced. And the court said, no, you can say, no, it's 1973. She's not 17 or 18 or 20. All the circumstances, both material conditions and personal circumstances, remember, both count. So she was a seamstress. What's the Serbian word? Seamstress. Oh, yeah, she was seamstress, and she could earn for a living. The court said she can be secure in another part of Nigeria. This high threshold, very exceptional circumstances, not met. But for the end, this is the case on the Red versus Austria. But the last one. The applicant was to be deported to India, country of origin. Married to a Christian, she had endured all sorts of violence and reprisals on the part of her Muslim father and brothers. The applicant alleged in particular that imposing her deportation to India would expose her to a risk of ill treatment. She's now in France. France wants to send her back to Guinea. And she's saying that would be a violation of Article 3 of the European Convention, actually the violation of the principle of law. What do you think? Or ask me anything else. Do you need more information to know whether this very exceptional circumstance standard is met?
What? We know what kind of information.
I will tell you. So when she met this young man, she fell in love, so you can see she was not in religion, and she started living with him and got pregnant. And then they were hiding, of course, in other parts of Guinea. But her father was a very influential imam, and he had, means to find them. He found them. He and together with his sons, her brothers, they entered into their home, took her away, beaten her husband, got him arrested. They took her to it was influential. They took her back to the family home, beat the hell out of her. The police, when they came, they found her tied to the tree. They took her to the hospital. She lost her baby because of that, and it took her 2 months to recover from that ill treatment. So this is the ill treatment she faced.
But the revised, I think it says on the basis of medical opinion. Why wasn't that he was in?
Why? Okay, we're now not talking about the example in France. So we're not discussing that. We are just discussing these gender dimensions of the refoulement. So whether what kind of risk, whether this very exceptional circumstance standard would be met, if she was returned. Anastasia, you wanted to add something?
That she will know that basically because of the
Why did she leave her home? Because she was forbidden by her family to be in a relationship. But this is something that happens to women disproportionately. Something like that would most probably not happen to men. There is such a problematic practice in Guinea in general. However, what you said, her father is very influential. You know what they did? She finally left Guinea and went to France. They followed her. They found her, located her in France. And then she was arrested in some railway station, and then this whole procedure started. If he had means to locate her in a country on another continent, just imagine what would happen back home. The crucial issue, you remember, whether she would be protected once returned to her home country. That's what the court deals with. Would she be protected?
He's influential that much.
Having in mind what happened to her already, what kind of ill treatment she suffered, she definitely would meet the criteria for refugee status. In these circumstances, it's obvious you have a well-founded fear of persecution because she's a particular social group, so young women who are not being allowed by her male family members to enter into a relationship with religion and yeah, but I mean the safer would be to go with the gender based argument because I mean they did not persecute her because of her religion, but because of the religion of the person she loved. So you understand the difference. In any way, you can see how drastic, very exceptional circumstances standards was meant here. So this is the case where the court actually said that it would be a violation of Article 3, and you can see that this is a very peculiar case which actually deals with gender-based violence and form of gender-based persecution that she would be facing in case she would be returned. And of course, the most important thing that she will not be able to get protection from the country of origin. But everything matters. You can see, starting with this brief description of the facts that I gave you, you might again think, no, but if I give you additional circumstances that would have given you completely different circumstances, that would be then the outcome would then be different. So everything matters. But what is a bit disappointing, we can agree on that, is that in such situations, for example, our FGM court still sticks to its very, very high threshold. We'll see whether this will change, but for the moment, this is the situation. So these are the relevant cases when it comes to gender aspects of the non-refoulement principle. Okay, what's the difficulty problem? Because this is not an easy area of law, especially if you are beginners. You know, I have to explain the basic concepts and then to come to this very complicated issue with non-refoulement principle and gender aspects of that. But I did not send you anything to read in advance. I will send you some interesting articles and materials together with the presentation, and it will also be posted on the group. So you will have it for additional reading. Any questions, any comments? No? Now you have who is a refugee. How gender matters in that regard, but we can have gender regardless as gender prosecution that women can count as a particular social group, meet that criteria, but also in non-hormonal cases, gender can all be irrelevant. But the court applies this very high threshold. So this would be the key messages for today. Gender-based violence may constitute persecution for the purpose of identifying refugee status. Women do count as a particular social group. Asylum procedures and reception conditions must be gender sensitive, but the CTHR case law has a high threshold in criminal cases, even in when it comes to gender-based violence, domestic violence, and other harmful practices. Shanka has something this evening. Yes. Enjoy yourself. Enjoy yourself. Side. Also, Mark Alexander, I don't know whether there is someone else online.
Yeah.
My life here.
We have no issue.
Questions?
Yeah, Dar Raju ma'am.
No questions, Professor. Everything was clear.
I cannot hear you. Who said that?
Yes.
I just did,
Everything
Professor.
clear. No problem. Dar Raju ma'am.
I cannot hear you. Sorry, but I
Dear
can't
Professor,
hear you.
Dar Raju ma'am. Everything clear.
Everything clear. Okay, that's clear. That I could understand. Okay, so this is the end from me for the moment, for now. We'll be working together for the Gender Equality Legal Clinic again in the second semester. But anything that you need, you feel free to contact me as always. Have a nice rest of the evening.
You as well, Professor.
Bye-bye.
Goodbye.
Bye bye, Professor. Have a good
Avala
life.
laku noche.